There appears to be a conflict of interest for the judiciary to continue to be influenced by the ABA and its supervision of the legal profession. Judges are supposed to be neutral and unbiased. The canons of judicial conduct contradicts itself by on one hand advising judges to refrain from political activity, and on the other hand allowing judges to become members of bar associations. Bar associations make recommendations to the state judiciary which become adopted and have the same effect as law. They give no notice or opportunity to comment. The ABA is an unelected special interest group which engages in political activity. The influence which the ABA exerts over the judiciary is undemocratic. So, what is the legal basis of the bar exam requirement? It's not in the U.S. Constitution. It's not in the state constitutions. It's not a law that has been presented and approved by both houses of the state legislature and signed by the chief executive. It's also not based on a court decision that has been rendered after an adversarial trial in which arguments have been made by both sides. For the most part, the practice of law has been supervised and controlled by the judiciary. However, rulemaking is a legislative function. Courts have no power to create public policy unless there is an issue or controversy presented. I understand that lawyers are the experts in their field. As such, judges and lawyers should have input on the regulation of the legal profession. However, their input should be advisory only. The final decision should be made by legislatures. It's hard to challenge a law in court when the law doesn't exist. The bar exam is not based on law. It's based on English tradition of having a legal profession that is controlled by practitioners. The term bar stands for British Accredited Registry or British Accredited Regency. When American lawyers receive their law licenses, they are not being licensed to practice American law. They are being given permission to practice British law. That is the reason that lawyers are called attorneys at law instead of attorneys of law. Lawyers practice law as outsiders of the legal system. Article 1, Section 9, Clause 8, of the U.S. Constitution states that, no title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them, shall, without the consent of the Congress, accept of any present, emolument, office, or title, of any kind whatever, from any king, prince, or foreign state. However, when attorneys are licensed, they are given the title, Esquire. This is a title of nobility which gives them permission to practice English law. The bar licensing requirement means that Americans are still subjects of the English crown. The American Bar Association is a member organization of the International Bar Association. The International Bar Association is based in London. The IBA is comprised of 180 bar associations and law societies. The International Bar Association influences the development of international law reform and shapes the future of the legal profession. Its member organizations cover all continents and include the American Bar Association, the German Federal Bar, the Japan Federation of Bar Associations, the Law Society of Zimbabwe and the Mexican Bar Association. The stated purpose of the IBA is to promote, protect and enforce human rights under a just rule of law, and to preserve the independence of the judiciary and the legal profession worldwide. In reality, the goal of the IBA is to control world governments through their legal systems. When attorneys receive their law licenses, they think that they are so smart for passing the bar exam. They don't realize that they are slaves for a foreign-owned banking cartel. If you really want to change America, you have to take the power away from the power elite and put power back into the hands of the American people. This starts by repealing the bar licensing requirement and taking power away from the American Bar Association.